Welcome back to the Law Show, brought to you by the firm of Kerrigan, Estes, Rankin, McLeod, and Thompson. I'm Randy Thompson, one of the board-certified trial lawyers at the law firm. And in this segment, I'm going to talk to you briefly about what your lawyer ought to be doing for you in an automobile accident case. First and foremost, it is all about credibility and truth and honesty about our client's injuries. If an insurance adjuster, or if we can't get the claim settled, then we have to go to a jury trial. If a jury believes that the plaintiff, the injured person, is not being honest, is not being accurate about how the accident happened, or about what the injuries are, or how the injuries impact them, then the case is over, because no jury is going to help somebody who they don't like. So what we know as board-certified trial specialists is that you must be credible. You cannot overreach. You cannot exaggerate. You cannot minimize, certainly, but you must be honest. And you must have all of your credibility intact so that 6 people on a jury think, well, this is a worthy plaintiff. This accident really has impacted this person and how they go about their daily life. On the way into the studio this morning, I received a phone call from one of the doctors in our area. Because we've been doing this for so long, we have a lot of relationships with doctors. We know them. We've taken their testimony in courtrooms. We've met with them in their offices so that they could explain the medicine to us. But one of the things this gentleman said to me this morning was he just wanted to take the time to thank my firm, the members of our firm, for being so candid and for being so upfront about our case. He made it very clear that not all lawyers do the same thing. This law firm would never refer one of our clients to a particular doctor for treatment. We believe that that is a medical decision that is best made by the injured person. It's best made by the person who's having the treatment done. So you should talk to your family members or your coworkers about what doctors they like and what doctors have helped them with similar aches and pains. Your lawyer's job is not to find you an attorney. And what happens is when it gets to an insurance adjuster to try to settle the claim, or when it gets in front of a jury and the jury finds out, and they will, well, how did you go to this doctor? Why did you pick this particular doctor to go to? And when your answer is, well, my lawyer told me to go to him or her, my lawyer sent me there, it just smacks of not being honest. It smacks of there's something fishy here. And there doesn't necessarily have to be that, but it's the appearance of impropriety. It's the appearance of trying to put together a claim that may not be valid. If, on the other hand, you pick the doctor because he's been your family doctor forever, or you pick the doctor because your family doctor suggested that you go see this new physician and she has now taken over your care, all of that makes perfect sense. What I tell my clients is, I don't care what kind of doctor you go to or who you go to. I just want you to go to somebody that you have confidence in, that you believe can help you get physically better. And I encourage my clients to not talk to their doctors about the lawsuit or the claim or what's going on, because the doctor truthfully doesn't have any impact in that. The doctor's role is to just try to make you physically more comfortable and to get you back on track to where you were before this car accident. So we like to keep the doctors out of the legal aspect of it. I like to have my clients not talk to their doctors about the legal aspect of their case, but rather, doctor, get me better. I'm feeling much better now. That's working. This isn't working. Talk to them about if they prescribe medications, how the medications are impacting you. They're doing great. They're not doing great. They're making me drowsy. But not about, listen, will you write a letter for me for my lawyer so that I can get the insurance company to compensate me? When those kind of conversations get into your medical records, it sends the whole wrong message to either an insurance company or a jury about why you're there and what you're trying to accomplish. So from a straight up car accident or any type of accident, this law firm, the Kerrigan Law Firm, and the partners in this law firm would never suggest a particular type of doctor for you to see or not to see, because that's a decision that you should make based on your own intelligence. Some people, for example, believe in chiropractic care. Others don't believe in chiropractors. It's up to you. If you think chiropractic care can help you get physically better, then that's where you ought to be. Not because some lawyer told you to go there because he plays golf with the chiropractor, or or they're in some group together, or they're neighbors. That's not why you should go. You should go to get physically better. And if you don't believe in chiropractic, then go check with your family physician and see if he or she can refer you to another type of doctor to help you. Okay. So I kind of went on a rant there about that, probably because the doctor called right before I came into the studio. But in reality, it is a really bad idea for you to go to a doctor because the lawyer told you to go and use that doctor for treatment. I will say this. There are doctors who we hire to do an independent evaluation of your medical records. And so in those cases, I might have my client go to a doctor for a visit so that the doctor could examine them, review all of the medical records, and then give me an opinion about what the future holds or what the nature of the injuries are and how they play out in a particular case. But that's the only example that we have of where we would send our client to a doctor, but it wouldn't be for treatment. It would be for a one-time evaluation, examination, so that we could have a better understanding of what's going on with our client. So that's my concept about that. Car accident cases, in the state of Florida, it is your car insurance that's going to pay the first 80% of your medical expenses. That's what's called Florida no-fault law. And under Florida's no-fault law, you can go to any doctor that you want to go to as a result of the accident. You don't have to have pre-approval from your car insurance. Now, some doctors say, look, we don't take car accident cases, and that can be. So you have to do a little more shopping around. And the shopping around, again, you should do is based on your own experience and your own belief and your own knowledge of what the various doctors can do for you and your thought process about how to heal. But it's your car insurance that's going to pay for the first 80% of the medical bills up to $10,000. It also will pay any lost wages you have as a result of the accident, 60% of those lost wages. Most people don't understand that in Florida law, that we have this no fault concept, that you can be in your car, paying attention, complying with all the rules, sitting dead still, somebody else rear ends you, and all of a sudden it's your insurance company that has to pay the first $10,000 of your medical bills and lost wages. The reason we have that law in the state of Florida is because the insurance companies wanted it that way. It was their decision. They thought it would make it easier to handle the claims, and they thought you wouldn't seek as much medical care and treatment as you normally would if you know your insurance is going to pay for it instead of the other person's. But that's the law in the state of Florida, and until the legislators change it, you can literally be walking down the street and a car hit you, and it would be your car insurance that has to pay the first part of your medical expenses. You can be treated by anyone you want to be treated by. You don't have to have pre-approval. So you can go to the emergency room. You can go to a walk-in clinic. You can go to your family practice doctor. You must seek medical care and treatment within 14 days of the accident under our new no-fault laws that were passed recently. I say new, maybe 5 or 6 years ago. I have been with this law firm for more than 27 years now, I guess. And this is all we do. So when I say new, maybe 5 years ago, the PIP laws changed and said that you've got 14 days after the accident in which to seek medical care and treatment. And, a lot of folks have an accident and they think, well, yeah, I'm sore, I'm stiff. I should be. I was just in a bad accident, but I think I'll be okay. And they sit around and they wait 2 or 3 or 4 days. And then if the pain is getting worse or not getting better, then you get on the phone and try to schedule an appointment with your doctor. But in light of COVID and in light of the pandemic, maybe you can't get in to see the doctor. But that 14-day time requirement is a very significant time requirement, and you must comply with it. So you don't have to go to the doctor right away, but certainly if you are in an automobile accident case and you are injured and you continue to hurt, you should in fact follow up with a doctor and be aware of that 14-day time limit. Well, folks, I'm Randy Thompson. I am one of the partners at the Kerrigan Law Firm. It has been nice talking to you all this morning. When we come back after this next break, we'll have more information brought to you by the law firm. The firm is made up of Bob Kerrigan, George Estes, Bill Rankin, Mike McLeod, and myself. We don't have associates. So if one of us agree to help you, agree to be involved in your case, it's going to be one of the 5 of us that are helping you. We're glad to do it. Check us out on the website, kerrigan.com, and you can also email us. You can find our emails on the website. We'll be back.